Hi, I'm James Crowson with Crowson Law Group. If you're watching this video, that means that your case is going to trial soon, and I would like to talk with you about what you can expect at the trial of your injury case. The first stage of the trial will be to appear on Monday morning and to select a jury. The attorneys both get an opportunity to question the jurors and talk with them about their experiences in life and how that might make them feel about an injury case. The attorneys can go pretty in depth about their experiences and about how they perceive injury cases, and the attorneys have an opportunity to what's called peremptorily challenge some jurors. In other words, they can get rid of some jurors without giving a reason. If a juror expresses any sort of opinion that might make them favor one side over the other, then the attorneys from one side or the other can make a motion to the judge to have a juror excused because they couldn't be fair to one party or the other. The judge will typically question that juror and determine whether he or she can be fair to both parties before deciding on whether to excuse them for cause. If they're not excused for cause, you can still excuse that person with a peremptory challenge, but you only get so many peremptory challenges, and at the end of the day, you're going to be left with a jury that probably no one is real excited about. The people that favor you or that you feel like might be on your side a little bit based on their answers, they'll be immediately scrapped by the judge or by the defense with their peremptory challenges, and vice versa. So we'll get rid of the people that don't seem to be on our side for whatever reason, and we'll be left with what's left, and that's your jury. Once the jury is selected and impaneled and sworn, we'll start with an opening statement where the attorneys will step up and talk about the case from both sides' perspectives and kind of tell the jury what they can expect the evidence to show. We can discuss the evidence that we expect will be put in front of the jury after the opening statements, during which we can't make any kind of arguments about the case. We can just talk about the evidence that we expect that will be in front of the jury. Jury will then hear the evidence that's put on the stand. We get to go first. We get to call our witnesses and put on our case in chief, which will include the medical documents that you have, any wage loss proofs that we have, any evidence, testimony from the people who might have witnessed the accident or who might have witnessed the aftermath and your suffering with the injuries. Of course, we'll put you on, and the case to a large extent will rise and fall upon your ability to tell your story effectively. Of course, you've worked with your attorney, and you have had an opportunity to discuss with your attorney the questions that are going to be asked and maybe the best way to answer them, so you'll be able to present that case in a compelling way to the jury. And after we present our case, the defense, unfortunately, gets to present their case. They'll put the witnesses that they think are important to put the case in their version of the facts. They'll put on different witnesses. They, of course, during our case in chief, get to cross-examine you and our witnesses and get some evidence in that way. And it's important to understand that relevant evidence can be presented to a jury. The judge is an umpire who decides what is relevant and what is not, what the jury is allowed to hear and what is not. A lot of times there will be discussions between the court personnel, the judge, and the attorneys at the bench that you won't be able to hear. They're going to talk about the evidence that might be coming out in the next few minutes and whether or not it's something that's appropriate for the jury to hear. Sometimes the court will be clear to the jury and we'll have arguments in front of you and the defense. We'll talk about what we want to present, and the judge will make a decision there. The judge's decision is final as far as the trial goes as to what evidence goes in front of the jury. Ultimately, we've tried the case. We put on the case that we wanted to the extent the judge would let us. We put the evidence in front of the jury, and we get a chance to close. We will get to close first and last, which means we will give our closing argument first, then the defense will give their closing argument, and then we'll have a chance to rebut their closing argument and talk a little bit more about our case. During closing arguments, As its name implies, we get to argue the facts. Unlike the opening statement, we get to argue what the evidence means and how the jury should interpret it. Ultimately, the jury gets to decide how they interpret the evidence and what evidence they accept as credible and what evidence they decide is not credible or they're not going to pay any attention to. And if you want to know what your jury is going to do, I should tell you that the juries do a lot of different things with cases. I've seen some interesting results. If you want to know who your jury is going to be, then I always tell people just go down to the Walmart and pick out the first 12 people you see. That's your jury. And there are people on the jury that are open-minded and willing to help, and then there are people on the jury who are not like that. And we're stuck with who's on there, and we're stuck with their decision. So the jury's decision is final as for the verdict. They will decide who's at fault. They'll decide how much each party is at fault, if you have any fault at all. They will decide how much your damages are. They will decide what you get for your medical bills, what you get for any wage loss. They will come up with a figure that they think is appropriate to compensate you for the physical pain and suffering that you experienced as a result of this person's carelessness. And that number will be the final verdict. And that's the amount that the insurance company will write a check for. You may have heard about appeals in cases, and there can be appeals in personal injury cases as well. An appeal is not, we didn't like the result. We didn't like what the jury said. You have to have a reason for an appeal. You have to bring an appeal that complains about something that the judge did, that something that the judge let the jury hear that they shouldn't have heard, or kept away from the jury that was relevant and that the jury should have heard as part of their decision-making process. So when you have a verdict that you don't like at trial, that doesn't mean that you get an automatic appeal and say, well, we just don't like what the jury said, we're going to try this again. That's not how it works. You have to have a reason that the judge messed up, and if an appeal is successful, that doesn't mean that they change the result of the jury verdict. That just means you get to try the case all over again, start to finish. So appeals, while they are available in a personal injury context, a lot of times they're just not worth the time and effort that it takes to bring them. And a lot of times, quite frankly, the judges don't make big, huge mistakes in personal injury cases. So there's not a grounds for an appeal in a lot of cases. So for all practical purposes, if the case is tried to a jury verdict, you can expect that that jury verdict will be the final result. At the end of the day, it's important to remember that a jury trial is not a huge deal. They happen every day over at the courthouse. You're just going to go try your case, and it's a case we know inside out. You know about your case. We know about your case. We're going to present the case in the most compelling way that we can, and we feel like we're going to get a good result, or we wouldn't be where we are now.